Hi, everyone. Good afternoon. I gather you can hear me well. Yes, I can't see very well. There's a very strong light. Welcome, everyone. It's really a pleasure to have you all here. I'm Mayra Martini. I'm with the Transparency International Secretariat in Berlin, where I have been leading our work on corrupt money flows. And it's really a pleasure to have colleagues here with me today to have a really good talk, I hope, about real estate and how the real estate sector has been used and abused by corrupt individuals to launder ill-gotten gains. And I have today with me Mary Butler in the middle, who oversees the U.S. Department of Justice Kleptocracy Asset Recovery Initiative. I have David Sacconi, co-founder of the Anti-Corruption Data Collective and also an associate professor of political science at the George Washington University. And last but not least, Daniela Castro in the corner, the South American editor for the Organized Crime and Corruption Reporting Project. And the idea today is to discuss a little bit what we need to do to make sure that the real estate, they are mitigating the risks of the real estate sector being used to launder corrupt money. We at Transparency International have actually been talking about this and the risks for quite some time now. Several of our national chapters have uncovered suspicious properties owned by corrupt individuals, and we collectively have been analyzing and proposing recommendations to address the main risks and the loopholes. I think the real estate sector is attractive for a variety of reasons, and as we have been talking about this, I guess most of people in the audience are quite familiar. But let me highlight three main things that I think enable money laundering to the sector and make the sector really attractive. I think number one is that it allows large amounts of funds to be placed in one single purchase. Then, of course, property ownership can be easily concealed, so distancing the corrupt individual from the asset. And then you can continue to launder money once you own a property because you can invest dirty money to renovate and improve the property, increasing the value. And because real estate property is being used to launder funds, I think the solutions that have been proposed and a lot of the focus that has been discussed, it is on the role of professionals involved in real estate transactions. So we at Transparency International and many others have been pushing for better regulation of the so-called gatekeepers or professional enablers, ensuring that they should have to conduct due diligence, identify the real owners behind companies that are purchasing property, and also report suspicious transactions to authorities. And while this is really important, this is not enough. And it has become very clear that there is another part of the puzzle, and that's one of the elements we'll be discussing today, which has to do with availability of real estate data. So to be able to really address this problem, we need to look at two key pillars. That is, are we collecting the data that is needed to understand the risks in the sector? Is this data available to those that should have access to the data? So competent authorities, but also journalists, civil society, and why not the public in general? And are we also regulating everyone who might be facilitating and involved in a real estate transaction? And before I give the floor to the panelists, I just wanted to mention that to address these issues and to shine a little bit more light on these two pillars of work, we team up with the Anti-Corruption Data Collective, and we are working on what we call the OREO index, so the Opacity in Real Estate Index, where we are analyzing 24 countries across the globe, exactly looking at these two different pillars. We are finalizing the analysis now. Many of our chapters and partners here in the room are involved in this. Maybe I can give as a very, very brief overview of the findings. I would say the bottom of the index, who is likely to be there. US, South Korea, and Australia, I think, are pretty much there on the bottom of the index. And France, England, and Wales are appearing quite high up, but we'll see what the final analysis will tell us. And one of the things, maybe I can also quickly mention some of the key things that are coming already from the analysis that I think would be relevant for the discussion today. I'll mention 5 very, very briefly. What became very clear to us is that we are much more advanced when it comes to anti-money laundering legislation. So in most countries, actually, the real estate sector is now regulated. Doesn't mean that implementation, supervision, and enforcement is good, but in most countries, actually, regulation is in place. And when it comes to real estate availability, on the other hand, most countries are really lagging behind. So the great majority of countries we looked at don't even have a central register where this information is available, not even to authorities, no? The other thing we were able to confirm is one thing that we have been talking about for really long, is the fact that beneficial ownership, so the real individual behind companies that are used to purchase properties, is also not being collected. Not available in land registers, but also not available in any other register that can be used to cross-check. And there are other 2 different interesting loopholes that even in the more progressive and transparent countries, there are loopholes in almost half of them related to foreign ownership of properties. So if you set up a company in another country and you come to buy a property, you don't need to register and you don't need to disclose any information, which makes there a loophole, important loophole. And the other issue is that in many countries, real estate developers are not covered. So if you are a real estate agent or a lawyer involved in a real estate transaction, you would be expected to conduct checks. But if you're actually involved in building huge complexes and you sell those directly, in many countries, there is a loophole and you're not going to be covered by legislation. So these are some of the findings, initial findings, and in the next months or so, we hope to be able to publish this and hopefully have another discussion. But let me move here to the panel. And I want to start with Mary, because your unit, Mary, has led investigations on many complex cases, many notable cases, and would be very interesting, I think, for us to hear a little bit more about some of the cases that involved real estate. And if you can tell us how easy or difficult it was to, one, identify the properties, and I think then connect the property to a potential corrupt individual, and some of the obstacles that you usually encounter.
Sure. So, is it working? Yeah? So, first, thanks so much for inviting me to participate. I think that coming to these conferences, and we come every time we're invited, is really energizing for us, because we know that we cannot do our job without the support of investigative journalists and civil society activists and NGOs, not only because they identify evidence for us in documents, but sometimes human witnesses. And so we know we can't do our job alone, and it's really heartening to see or be reminded of how many committed people there are out there to help us do our job. I should say also first, to be a lawyer in the United States requires a lot of academic involvement, right? 7 years of school, bar exam. So I don't like to hear that we are getting failing grades. In fact, we're at the bottom of the class. So we'll hear more about what the rating system is, but I think that what might be true is so few of our available tools are available to the public, but we do have some more disclosure tools available to law enforcement, and we rely a lot on those tools. And so I'm hoping that our ultimate evaluation might look like how we were evaluated by the FATF the last time. We failed on beneficial ownership disclosure, but we rated really high in effectiveness because we work hard to work with our disability. So we'll see how this comes out. But I am interested in sharing with you the three sort of main typologies that we see for real estate connected to corruption that has a link to the United States, because maybe it helps inform you about how best to generate the kind of leads or information that can help you expose corruption and then give us the possibility to act on that. So first, I think we, maybe just so you understand a little bit about the mechanism before the typologies. In my work, we use mostly money laundering laws. And our money laundering laws can be used to attack transactions that conceal, that promote, or that or are proceeds of corruption. Our predicate crimes, different from most countries in the world, include almost all US law violations, not all, and that's a FATF negative there, but also we have foreign law predicates. So we can use financial transactions connected to a violation of another country's bribery, misappropriation, embezzlement, bank fraud laws as predicates for our money laundering transactions. And that really extends our reach. But what we need usually is a financial transaction connected to the United States. But especially for real estate, it could be a transaction to purchase real estate in the United States. It could be a transaction to subsequently improve the real estate or to pay costs associated with the maintenance or ownership. But it could also include where money moves through U.S. correspondent accounts to buy property overseas. And so our reach is broad where we have appropriate evidence. And with that background, this is a little bit about what we've done, but I'm happy to talk about that later. Of the three circumstances that we see commonly, first is the one which is relatively easy, right? Money is embezzled. So that's easy to prove usually because it comes from a government account to an account it should never be in. And we just follow the money to the asset. And in this case, usually we find that the asset is in the name of the thief, or it's in the name of maybe a nominee or a shell corporation. But these are not substantial hassles. In our 1MDB investigation alone, I think we had 12 or more luxury properties that we could trace stolen money to in the United States or through correspondent accounts to London and to France and to Hong Kong. But it was relatively easy because we had the money coming. We didn't need a witness to show us that the money went from government accounts to an account controlled by Joe Lowe, and then to move into the United States where properties were bought in the names of shell companies held by many different individuals. So this is the easiest kind of case. And of course, we love to see these because our mission is to confiscate, return assets for the benefit of the people harmed by the corruption through agreements that ensure transparent and accountable use. So we like the easy ones because we can then show impact. In this case, we both used civil, non-conviction-based confiscation, which is our most commonly used tool, but we also prosecuted people criminally seeking forfeiture. The criminal forfeiture cases didn't involve recovery of real estate. The second most common scenario we see is money is invested directly into real estate, either in the name of a corrupt official. Sometimes people make that mistake. Or they use a corporate or individual nominee. And sometimes we know they own that property, because we can do some digging through material available to us, or because somebody tips us off. But we don't know the source of the funds. And a typical example of this is the former president of the Gambia, Yahya Jammeh, owned this $3.5 million house within sight almost of our offices. And that house sat there for many years. And people would remind us all the time, you know, the former president of the Gambia, the current president of the Gambia, who's a dictator and a ruthless guy, he owns that house, and what are you doing about it? Yes, thank you. We know that. So, but the way it finally cracked open was because, well, first the Washington Post told us in 2017 that he owned it, which was great. Then we could find the admissible evidence that confirmed that. But it wasn't until 2019 when the Gambia completed its investigation into Jammeh's conduct that we were able to link the ownership, the money to purchase it, to crimes that violated Gambian law. And so in turn violated our money laundering law. So with their information, we then filed this civil non-conviction based case, and we we forfeited the house, and we now have sold it, and we're sitting on the cash. And the Gambians have told us that they want to use this money to fund their victims' compensation fund, and they are working on the legislation and the regulations. And when those are in place, then this money will be used for that purpose. We will give it to the Gambian victim fund. So again, this is a common scenario where we need some help from our friends. But this one is the hardest one. This is money invested directly into real estate in the name of a corrupt official or corporate or individual nominee. But we don't know that they own the property, and we don't know where the money came from. And as David and I were talking earlier, this fits into that problem of how do you estimate how much corruption proceeds are out there in the world. How do we know? Maybe we can set some threshold numbers, but there could be a lot of this in the United States because it's a relatively stable economy, and people like sunny climates like Miami and Los Angeles, and they like the thrill of New York. So there's probably a lot, but we don't know. And this is where we really need help. And here's an example of one case where we got some help. So this house over here is in Malibu, California, overlooking the California coast, the ocean. The house, the Michael Jackson memorabilia, the Ferraris and other stuff was bought by Teodoro Obiang, who was then the second vice president of Equatorial Guinea. We didn't know he owned the house. We didn't know he bought Michael Jackson paraphernalia or these cars. We were pleasantly surprised when Global Witness wrote that article, Secret Life of a Shopaholic, and we learned about the house and other things. And then we used that information to develop evidence admissible in our court. But we still needed the information about the predicate crime. And there we got some help from Open Society and some others who actually found witnesses who had been extorted by Obiang and were willing to come forward. Now, for a prosecutor, it's a scary case to have all your witnesses outside the United States. So you can't protect them, but you have no compulsion power. So it was a good case to file, and we did. It was called U.S. versus One White Crystal Spangled Glove, worn by Michael Jackson in the Bad Tour, and a residence on Sweetwater Drive, because in civil cases, the defendant is the asset. And this is one reason why this tool is so effective, because we don't need jurisdiction over the person, just the asset. And anybody who thinks that they own an interest in the property that is protected by our law can file a claim and fight with us. And I can tell you that when it comes to real estate, we sometimes get a mistress or two. Sometimes we get a kid or a beneficiary of a trust. But for the most part, these are not interests protected by our law. So bye-bye. And then we're in a position to try to return money for the benefit of the people. But in this case, we only forfeited, we reached a settlement where we created a fund to return money for the benefit of the people of Equatorial Guinea, and we reserved 10 million of it for forfeiture. And we wanted 10 million for forfeiture because we wanted to say, this is dirty money that you brought into the United States. We wanted him to have to admit that, not just that he settled a dispute with the government and agreed to return money for the benefit of the people. So something that was important to us, and I guess he was willing to do. I think those are basically the examples and the lessons that I wanted to talk about, but I'm happy to take questions at a later time.
Yeah, thank you. Thank you so much. That's very interesting. And I guess we are definitely interested here in the case tree type of the case tree, right? Where the things we don't know and what we need to have in place to ensure that we can start learning about them. No? And I guess that's where these two pillars that I was talking about are really important. And I think this is a really good segue to Daniela, because a lot of the cases that we know thanks to leaks, right? Particularly because information is not available. So I wanted to hear from you, Daniela, as a journalist also. How often in your work do you encounter properties that authorities didn't know themselves, that potentially are connected to corrupt individuals? And how are you going about finding those properties and linking them to potentially corrupt individuals?
Yeah, so can you hear me? No? Yeah, okay. So yeah, there are a couple of things that I want to speak about properties. The first thing that we do when we start an investigation is look into the properties of the person of interest. So it's like assets in general, but that includes the properties. There are some projects that we have done that are focused on finding out if political figures sanction individual or alleged criminals and their relatives, because I'm going to speak about an investigation that we did a bit later, where there were like some relatives of people involved in corruption cases who had like properties. So we look into the person of interest, but also on the relatives if they have any assets. And there are cases where we know that authorities have identified some of the properties. So, for example, we did an investigation that we published on July 2022 about a Peruvian narco who was arrested in Argentina. He was being investigated on money laundering charges. So the authorities have already identified some properties in Argentina that he had bought. But in the reporting, the Peruvian reporter found other land properties, other land and properties in Peru. We don't know if the Peruvian authorities knew about these properties. At the time that we published the investigation, the Peruvian authorities were not investigating this narco. So this is probably new information that the authorities in Peru could use. So in Argentina, they had identified some properties, but in Peru, with the reporting, we found some properties and land parcels. There are other cases in which we, when we look for properties, we have like more information about other things. So, for example, we published in November 2023, like last year, an investigation about the son of one of the leaders of the Cali cartel in Colombia, who was trafficking on processed shark fins. We had the corporate record, and in the corporate record there was like an address. The reporter went underground to look for the company, and we found out that the address that was in the corporate record didn't exist. So the reporter started asking neighbors about this company. That's how we found out about the real address. With this address, the reporter got the property records, and we found like this person had other properties in that small town near the Pacific coast. So it was like with one information, we were able to get more information about properties that were linked to this son of a former drug leader. And just a last example, it's connected to the Open Lux project that was published in December 2021. Luxembourg in 2019 made public a partial registry of beneficial owners. So you could search for information with the company name and the registration number, but not with the person's name. So Le Monde scraped the data and it made it searchable. Thanks to that, the reporter in Venezuela was able to find some properties in Dominican Republic, luxury villas in the Dominican Republic, and shares in a hotel in Cartagena in Colombia, because in this database there were properties connected to people linked to alleged corruption in Venezuela, and these companies in Luxembourg own these properties in Dominican Republic and in Cartagena. So this is all public information. They have, like, answering to your second question, we use a lot of public information to uncover like ownership of people that we're investigating. There are also cases of properties that we are able to like connect to people of interest through leaks. So that's the case of a project that we published recently with other media outlets in May this year called Dubai Unlocked. This is leaked data from the Dubai Land, I don't remember the Dubai Land Department. And thanks to this data, El Universal, which is a Mexican media outlet, published, like, or found that there was the son of former governor who had been also involved and investigated on corruption, on a corruption case, owned 3 properties in Dubai. They were worth about $5 million US. So we use leak information as well to find properties connected to people of interest. But as you have seen, like, we use a lot of public information. There's a lot of information, public information out there that we can use.
That's great. I want to get back to you on another investigation you did on France, but maybe first I pass on to David. But a comment on the Dubai Unlocked, because I think it's quite interesting that those cases that were uncovered now wouldn't fall in Mary's category 3. So you would have thought that authorities in the UAE should have been able to deal with them long ago. So most of these properties are actually owned, I think almost all of them that have been reported, on their own names of individuals. And the number of politically exposed people who have now been identified is quite significant. And we're talking about people who clearly their official income won't match what is needed to buy a property there. No? So it raises a lot of questions, I think, on the fact that the data is there, is available, is a leak of the land register, but yet authorities were not making use of it to pursue case. But I guess we leave that for later. But David, let's turn to you now. Daniela was talking about countries that are starting to make more information available. And I know you have been working with publicly available data in trying to identify cases, but also policy issues and so on. Can you tell us a little bit what difference it makes when you have access to data?
Yeah, so I work for something called the Anti-Corruption Data Collective, and we bring together programmers and data scientists as well as journalists to analyze data in bulk, right? So journalists often get a lead and they'll go to public data sets and try to pursue that to the very end. Whereas the countries that we start with, we try to vacuum up all available data that's related to real estate and then connect it both to generate leads for cases for investigators or for law enforcement, but also to tell you something about how the system is working or not working. So I'll give you the example of France, which is like one category of work, where France is kind of one of these middle cases where they have pretty open land records, especially when it comes to companies, right? Individuals have privacy rights. We don't know which individuals own what, but we do know which companies own which parcels around the whole country. And it's one-click download every single year, updated quite regularly. It's quite impressive. On the beneficial ownership side, it exists. It's publicly available, but not in bulk form. So we had to scrape 6 million websites in order to build a database of all the beneficial owners of companies. And we basically merged the two of them together to try to show, wait, 71% of corporate-owned parcels across the country of France never even declared their beneficial owner to the government. So the government is in the dark about who owns all these parcels, even if it can't do anything. I'm not sure which category that is, probably 3. And it's alarming in something like Paris, less than a third of corporately owned parcels even declare their beneficial owners. But what was interesting, of the ones that did declare, we found incredible cases and shared them with OCCRP, and they went and grabbed the records and wrote the stories and grabbed the headlines because of that. And now the law enforcement is kind of working to pursue some of those cases. So the information was in the government's hands, but because it was disclosed, we could uncover it and then share it. So I understand there's arguments why we can't disclose data, but I'm very fundamentally the idea is the more people looking at the data, the more cases you're going to catch. And some of the examples of the spreadsheet relied on civil society and journalists using creative methods in order to get data and being ahead of government. So I think you do want to share data because you often find things that governments just don't have unlimited capacity to pursue this. And then the second example I'll talk about briefly is we don't just map things. We want to figure out what policies are working and not working. So the UK is pretty stellar when it comes to data availability on most of these different dimensions. And there's people in the audience like Sam who've worked with the corporate ownership data for a long time and showing the flaws, but also how things are maybe improving over time in terms of Companies House registry in the UK. Well, we took the Economic Crime Bill, which introduced transparency in terms of foreign companies in the wake of Russia's invasion in 2022, and wanted to see whether or not transparency changes the behavior of bad actors in the way they approach real estate. So if you have to declare if you own a real estate parcel to the government, does that decrease the attractiveness of investing in the real estate? And what we find is it does, right? Passing transparency laws reduces the appeal of investing in real estate, but only if the data is made publicly available, right? The condition where you get this deterrent effect is that it's available to everybody, because that's what bad actors care about. They care about stories and newspapers. They care about civil society calling them out and naming and shaming, and they care about law enforcement, of course, bringing them to justice. But it's everybody working together where you have the biggest impact. And in the UK, it just gives us some of that first evidence of the positive impact of transparency. We love to think it's this incredible disinfectant, but we don't always have the data to back that up. And I think because the data was made available in the UK, we could analyze transparency and try to make a stronger case in other jurisdictions that these companies or countries should be copying the UK model, and they might see immediate dividends. We're talking 6 months after the law was passed, you're already starting to see a decline in interest in the UK real estate sector among shell companies from around the world and offshore havens. Great.
I wonder where they're moving.
We look, right? We look for substitution effects. I'm sure they're all in Dubai. It's hard. If you can't see everywhere, you can't see where they escaped to. But maybe in 10 years we'll figure it out.
No, great. Those are really good examples. And I don't know whether there are colleagues from Transparency International UK in the room, but maybe in the Q&A they can come, because also the number of cases that have been uncovered since the register became publicly available is also quite impressive, showing once more how powerful that can be. But Daniela, maybe turn to you again if you want to tell us a little bit more about the cases that you found in the French BO and real estate data.
Yeah, before I go to the findings, I just want to give like a brief context of what was going on in the EU when we did the investigation. I think that's important information, and also like sort of the data that we use that David explained a bit, but I want to get more into that, and then I'll give the cases that we found, like the findings. So in the EU, so we published this investigation July 2023. In 2022, the European Highest Court shut down rules that required member states to keep information about beneficial ownerships available. 8 member member states, immediately closed the access to this information. In France's case, they kept it open. At the beginning, they restricted the access a bit, but then they kept it open, and that's why we were able to do this investigation. OCCRP's partner, BIRD, which is the Bureau for Investigative Reporting and Data, they downloaded, scraped, and processed information published by the French government, including French properties, companies' beneficial ownership, and real estate holdings. And they created a search engine that allowed reporters to connect the dots between the companies that were set up in France and the properties that were owned. The companies that were set up in France and the properties that were owned by those companies and the people, of course, behind the companies. So that's like how we were able to find these people who were behind the actual properties. And there was something very particular about France, because in general, like, we have like these layers of companies that own properties, and we usually don't know who's behind the company. But in France, it's pretty common to have companies that are just like created to own real estate. So at the beginning, we thought it was a red flag, but then with the help of reporter from Le Monde in France and also from TI, the chapter in France, we were able to understand that it was pretty common, so that's important for the investigation. And yeah, in July 2023, we published an investigation with a series of stories, 2 related to Venezuela, 1 to Peru, and 1 to Brazil, of alleged money launderers and officials and relatives of these public officials accused of corruption who bought properties in France through companies they set up in the country. And just like before I mentioned like the findings, I want to say that this project was really important because it highlights the importance of having public access to this information. As I mentioned before, we wouldn't have been able to do this investigation if the information in France was public. So yeah, it's like a really good example of why it is important to have public and free access to beneficial ownership information. So yeah, on the stories, I want to focus on the ones that are related to Venezuela. On the one hand, because it's really difficult to get information from the country. And on the other hand, because public officials who have allegedly stolen money or received bribes have stashed the money abroad. So in all the investigations that we have done with Venezuelan reporters, we have found that it's really important for them, like the leak information that we get from the leaks, but also from public information in other countries, because that's how they have been able to find where the money that has been stolen in the country ends up. So one of the stories involved the relatives of a former Venezuelan minister of transportation accused of receiving bribes. Reporters found one apartment in Paris worth 2 million euros. A couple of years before the apartment purchased millions of dollars in alleged bribes from Odebrecht, followed into bank accounts that were controlled by his wife and his mother-in-law, according to European investigators. And the reporters also found 2 other apartments in Paris connected to his mother-in-law and brother-in-law, one in the same building and one on the same street. The other case involves a Venezuelan businessman allegedly investigated for money laundering in the US. We said allegedly because this was reported by the Miami Herald, according to a source. But this wasn't public information. It was like closed, it was an investigation, like ongoing investigation, but we didn't have access to information about it. So we were relying a bit of what has been reported by the Miami Herald. So that's why it's alleged that it was involved on money laundering. He was involved in money laundering. We found, or the reporter found, a property in the French island of San Barthélemy in the Caribbean. Friends records show that in February and March of 2022, the French authorities have seized the properties as part of an ongoing money laundering investigation. So those were the two big stories of people of Venezuelan who had been involved on either corruption cases or money laundering. And there is a third name that we didn't include in this series of investigations because the reporter who was working on this project was also working on another story that was published one more month later. And this person was more relevant to that story, so we kept that information for that other investigation. It was mentioned like the Paris property that we found in the database. But the interesting thing about this name was that he was like a nobody. He was not like a, like a public official or like a known person in Venezuela. And the reporter kept, like in the projects and leaks that she had been working on, she found this name very often. So, like when she found his name again in this database of properties in France, and then in the other investigation that she was working on, she found out that he was an enabler who helped the former head of the country's treasury to launder money that she stole from the public funds. So just like to say that sometimes we usually focus on the names that we already know, but by like looking at this information that appears, like these names that appear in other public records or leak information can also lead us to new people, new characters that are also important and are helping these corrupt people to hide or move the money.
Great, no, and great to see also the impact is good to see that French authorities are now looking into some of this case. We know they also open investigation into other cases that we also highlighted in our work, in particular related to Russian officials, so it's good. But let me tell another anecdote before I move to David to talk about the US. That is when we were working on analyzing the data from France, David and I and our colleagues from TI France had meetings with French authorities, and it was really interesting that the first time that they stopped to analyze the data was to be able to respond to our analysis. So they never had done an analysis themselves of the database to try to understand some of the risks and red flags and patterns and so on. And they actually had to stop to do that, to compare their numbers with ours. So it was interesting to see. But let's go back to David and also to talk a little bit more about the US. So you recently published some analysis of commercial real estate in the US, which I think is quite special. In many other countries, you don't really necessarily have a differentiation between how commercial and residential real estate is regulated, in particular for money laundering. I think it would be interesting for us to learn a little bit more about the risks and things you found.
Sure, and I should have mentioned from the outset that TI France was like the critical player in the French report. And the government responded to TI France approaching them with this analysis, and how many different agencies were on that call. Like, it was a really collaborative, interesting interaction, and I think that having such a strong chapter there made the impact of the research much better. We just finished a report with Global Financial Integrity and the FACT Coalition on the U.S., and commercial real estate is quite controversial in the U.S. for a bunch of reasons. One is there's not necessarily been the same amount of scrutiny or transparency in the commercial real estate sector as there has been residential, and we define commercial as basically anything that isn't a single-family home. So anything that's being rented out, or it could also be movie studios and factories and equestrian facilities, you name it. So things that have basically an investment purpose. They're designed to grow wealth, not just enjoy it. And it's hard to do this type of research. Honestly, the DOJ is the best source of information. We got all of their press releases of every case that they ever pursued and seized assets on commercial real estate. There were 35. We wanted more. We thought that $2.6 billion was probably a fraction of the amount of money being invested in commercial real estate, but that's how much the DOJ had seized and had documented very clearly. Like, these are the different types of assets. These are the different types of enablers that were involved. And then we could also piece together from different reporting and do some in-depth cases, but also take a step back and analyze, okay, even with 35 cases, what does that teach us about the landscape of money laundering into commercial real estate? And I don't know, I was surprised in a couple ways. One, it comes from everywhere around the world. It encompasses just about any type of criminal activity, everything from organized crime to kleptocrats to white-collar fraud. It really took a variety of different forms. It didn't just go through shell companies. There were different types of institutional funds and special purpose vehicles, holding companies, EB-5 violations. They were pretty creative in the type of legal entities that were used to channel money into this. There were some really complex transactions that involved multiple players and loans, and there was also pretty straightforward stuff where it was basically the same as a residential real estate transaction, one legal entity buying a property. And then the cases. I mean, the one thing we really focused on in our first case is Sephira Capital, which is, you may have worked on this case, the black market peso exchange. So a sophisticated cartel money laundering operation, and American enablers who created special purpose vehicles and helped distribute the illicit funds into over 15 commercial properties across the East Coast, mainly in Florida. And I think the fine was $42 million that was seized by the DOJ going after Sephira Capital. So we really talk about how this case is illustrative of the vulnerabilities in the U.S. commercial real estate sector. And we shared it with our friends at the Miami Herald just a couple weeks before the publication of the report. And we said, hey, you guys have a Florida beat. Maybe you could poke around and see if this is a story that you could do more on. So they took the name of Sephira Capital, they got all the different legal entities, and they ran them through the Pandora Papers, and they found a bank account that had never been seized by the DOJ. And that throughout the entire criminal prosecution and punishment of all the people that were involved, they probably didn't have visibility into this offshore bank account, and that it was most likely that the perpetrators of the crime were still enjoying the proceeds because it hadn't been caught in the full swoop. That article came out about 3 weeks ago. So it's interesting that even with the limited amount of data that we have, you can start to piece together with leaks and things like that just about how vulnerable this sector is. So I'll end with a little note. There's a lot of pushback in the US, like, you don't have to worry about commercial real estate. It goes to the banks. It goes to the loans. We just find that, again, it's so diverse in the way that money is moving that you cannot give the banks a free pass, because we found Ukrainian oligarchs. We found all these like malicious actors taking advantage of systems that were designed and supposedly had the protections to prevent this from happening, but they broke down in really significant and alarming ways. So there's debates in the U.S. about whether or not commercial real estate is already under control, and hopefully this and other reporting starts to kind of focus people's attention that we have to include it with residential real estate rather than put it to the side as if it's a special category that's already been dealt with sufficiently.
No, great. That's super interesting. But just a very quick follow-up question. The U.S. recently proposed to regulate the real estate sector. And is my understanding correct that this wouldn't address this problem because commercial real estate is not part of it, or would?
It's specifically excluded from this current rulemaking process, which we are by and large supportive of the proposals that are coming through. Commercial real estate is not covered, but I don't know how the quality of our sources. It sounds like commercial real estate is still in process, that there is going to potentially be the same type of approach assigned to commercial real estate, but we don't know a day when that's going to happen. But in the report, we make a number of policy recommendations. Is that, I don't know how familiar you are with the U.S. rulemaking process, but there's like a cascading approach to disclosure. So there's all the different actors in the real estate transaction, and they can't pass the buck. Somebody has to report on beneficial owners, and we say, look, if you're going to do this for residential, you should do it for commercial. And the same rule should apply for all the different sectors. It's just not clear if that's going to happen in the same way and when that might happen, because we think there's going to be a lot of lobbying by the commercial real estate industry, which is under a lot of financial duress right now in the United States, that additional regulation is not going to help solve the systemic problems facing the sector.
Great, thanks. Mary, back to you. So David mentioned now just the role of the enablers, right, in the US. In many of the cases, you also highlighted certainly involved real estate actors, lawyers, and so on in the country. So I was wondering whether you could reflect a little bit on the role of these professionals in the country, and how difficult it is sometimes to stop their
Yeah.
behavior.
So if we just go back to the 1MDB example for a moment.
Could you please show the slides again? Yeah,
Oh,
thanks.
sorry. So embezzled money came into the United States into commercial real estate, the ownership of boutique hotels, management companies for boutique hotels, the redevelopment of the Park Lane Hotel, which is the last undeveloped property, or last recently undeveloped property facing Central Park, so really premium property. So lots of other commercial real estate. But this was easy because we followed the embezzled money to the asset. And then we just needed to confirm that it hadn't been sold again to a bona fide purchaser for value. But if it had, then we would try to chase the sale proceeds. So again, commercial or residential, not such a big problem if it's embezzlement. But if it's not, then yeah, more complicated. One of the things that came out of 1MDB is we saw for the first time buyers and sellers cooperating to simply sell the shares of the shell company. So completely avoiding title companies who have disclosure obligations if there's a deal in cash. Also avoiding title registry, which would happen if there was an independent sale by one corporation to another. So we're watching for that kind of thing to happen. Enablers, right, the lawyers who are orchestrating these deals, they know exactly what they're doing, and they are compensated highly for these kinds of services. But one of the other things that we saw lawyers doing in 1MDB was allowing their trust accounts at banks, for which there is very little know your customer due diligence performed by banks. Bank trust accounts were used as bank accounts for clients. So a firm in New York allowed Joe Lowe to use their trust account to pay gambling debts and buy gifts for people. It's nothing to do with legal transactions, which can be another dangerous way to conceal money laundering. I also, obviously, enablers it doesn't take a lawyer to incorporate a company, but lawyers are often involved in it, and when they are, that's a problem for the United States because the big hand in front of our questions comes up and says, this communication is subject to attorney-client privilege. And sometimes we can get around that by showing that either it was to facilitate a crime, the communication was to facilitate a crime, and the lawyer knew nothing about the crime, but still has evidence they should disclose, or the lawyer was in on it. But this type of, to get past this hand, takes significant investigation. So lawyers who create these vehicles to hold property are problematic. The leak for Panama Papers was quite helpful. Even though lawyers were involved, it was possible to have what we call taint teams or filter teams of prosecutors and agents review material, strip out what might be communications between lawyers, and isolate information that doesn't have to do with the provision of legal services, and then provide it as beneficial ownership registry. Not a lot of those properties actually had a connection to the United States. We scoured that data for that reason. So it's a big speed bump for us.
Thanks. No, that's very, very helpful and interesting. And one last question, and then I promise I will stop abusing my moderation powers and we'll open for you all to ask questions as well. But Mary, is there anything you can tell us about trends you are seeing? Because things are evolving, right? We have more access to data, we have more transparency. So what it is that criminals are doing?
Well, the one thing I know is that, and don't share this outside this room, we only catch the sloppy, stupid people, right? We catch the people who make mistakes because they disclose themselves as connected to the property or connected to the crime. But thankfully, it's not just those people who are the direct beneficiaries or the criminals themselves, but everybody who knows about it. And as that circle grows or is big in the beginning, somebody in that circle will make a mistake. And we will be there with your help to capitalize on those mistakes. There was a New York Times story written by Louise Slater, I think her name is, some time ago, which actually helped us find, actually it was before we even knew about the embezzlement, about some of these properties in New York. She was identifying what very suspicious people around the world owned properties in high rises in New York. And she talked about this gumshoe sort of detective work of figuring out who paid the taxes, talking to the doorman in the building about who actually stayed in the property, asking people who would ask their homeowners association for the records of who was staying in the property. So people make mistakes or think that we aren't looking, and we capitalize on that.
Great, thanks a lot. So now we can open for questions from the floor. We have good 30 minutes for discussion. I think there is a mic around. Please just raise your hands and I will collect some. Yeah, thanks.
Great, thanks so much. My name is Sasha Caldera. I'm from Publish What You Pay Canada, and my question's for Mary. So we have a similar problem in Canada with respect to real estate-based money laundering, both through commercial real estate and residential real estate. And so in Canada, about 86% of money laundering charges get dropped due to the phenomenon of the hand that you just mentioned. And I'm wondering, like in your perspective, like what kind of policy mechanisms or even enforcement measures should states like undertake to sort of mitigate the hand in these circumstances where money laundering is suspected and there's a reasonable case to prosecute, or whether or not we need to add more predicate offenses, for instance. So really curious to hear your thoughts.
Great, let's collect some more questions. I think there was a hand here in the middle.
Thank you very much. Super interesting. Happy to listen to that. My name is Peter Huppertz from the Basel Institute on Governance, and actually I have two questions. You can drop one if it's not okay to have like two. So one is a bit like going away from the real estate, but the general cooperation between journalists and law enforcement. So for me, it sounds like it could be super beneficial to probably start that before the article comes into the news. I wonder if there are models that you do it, if you see that could be beneficial, or if it's more making your life harder because it might be a problem for you to even continue your investigation then. And the other part is you talked about it like the right of privacy versus open data. Do you have like the magic way, what is the best to what kind of data to expose and how to probably still have the right of privacy of your ownership, or should there even be a right of privacy? I don't know. So would be interesting to know your thoughts about it.
Thank you. I think there was one hand in the back, and then we can answer, and then we do another round.
Hi. My name is Nedim Hogic. I'm with the University of Oslo. My question is for the representative of the Kleptocracy Asset Recovery Initiative. And the question is, have you seen a change in the enforcement patterns, for the better or for worse, in the last few years since the U.S. strategy on countering corruption was passed? Because that was a really important strategic document, not just for the U.S., but on the global level. And it really highlighted money laundering and also money laundering in real estate as an important problem. So would you say that things have changed now, that this issue has been sort of elevated to almost a matter of national security in the U.S.? Thank you.
Thank you. Mary, you want to start?
Yeah. So first, I should say that as to some of these answers, these may reflect more my personal views than the department's, in part because we have for example, to go to the policy issues, we have policy professionals. I'm actually trying to catch bad guys, so I'm not in the clouds quite so much, stepping back. But my principal deputy is here, Dan Clayman is here at the conference, and he is this kind of brilliant guy who does both. So he may have some more ideas for you. But I think that one of the things we have to do is to deal with attorney involvement creating secrecy, is we have to be more clear about what is the provision of legal services and what isn't, and have disclosure obligations for what isn't legal services. People have lawyers do these things so that they can cloak themselves in secrecy, but much of this work doesn't require lawyers. And so I think that's one thing we have to do, and there is some legislation pending in our Congress to try to do more of that. But I think also we need to make sure that the disclosures that are required are truthful. And to do that, we probably need more investigators, and on the administrative side at FinCEN, who have the ability to actually expose some inaccuracies and impose penalties. And it doesn't help to impose the penalties against foreign property owners. You have to impose the penalties against enablers who act in the United States, who have licenses to act in the United States that could be impacted. So in brief, that's, I think, one thing we have to do. If we had more prosecutors and investigators doing anti-corruption work, we might be able to do more of the kind of hard work of proving a crime-fraud exception, which is the thing I was talking about before. So we might be more effective even with the tools we have if we had more resources, but who's to say this is the most important place to put all of our resources? With regard to the relationship with journalists and government, I'm particularly sensitive to this because I have seen the value of journalists' work. I do think that pre-publication disclosure to prosecutors is important, but it's more important where there are potential witnesses than it is if the witnesses are not available to the prosecutors. Here's an example. When I did corruption work in Miami, and there's no shortage of that there, the Miami Herald investigators who had great sources would come to us and say, this guy has a contract at the airport, and he says that he pays X, who represents this public official for these contracts. When they would tell us that 2 days before they ran their story, we could go out, the FBI could go out and knock on doors and catch people, unaware in their underwear, and see if they would lie to us and we could prove it was a lie. Or they might tell the truth. Or we could identify more people whose doors we could knock on. And then we really could open things up dramatically from the ability to prosecute. In the kind of cases we do now, there's so rarely a human within our touch, unless we have a close working relationship with foreign investigators, where we could say, hey, this is the guy you need to talk to, and right away. Or if that person happened to be in the US and wasn't a lawyer who would do that. So I think it's still important, and we would like to take advantage of it every time we can. But I think it's most critical in the situation where there's lawyers, where there's witnesses within our law enforcement reach. About the patterns since the strategy was announced, I think certainly our Congress passed some legislation which helps us do our job better. They gave us 2 more years on the statute of limitations for these money laundering offenses that involve foreign crimes as predicate crimes, and that's really helpful to us. They also have done some things which allow us more flexibility in how we return funds. We need some more help with that. I think in terms of whether, then they created this statute that allows the substantive crime of bribery to be prosecuted, not just the bribe payers. we always would address that through money laundering, but suppose there was a solicitation for bribery and no money paid. Well, now we could prosecute that without the money laundering tool. So there's been some legislative support. I think awareness is way up in terms of what we should be doing. I can't say I got any more lawyers or any more investigators as a result of this process, but that could be coming down the road. Definitely awareness that the United States has a lot of work to do in this area, because we, not only because of our own security interests domestically, but our security interest in our partners, because this corruption is so destabilizing. And if we are enabling it, then this is a problem. So that's my take. I'm not sure I'm a good person to talk about right to privacy and open data. Maybe one of our colleagues.
Yeah, you want to try to answer to that one?
Maybe you should.
I should answer.
Yeah.
Do you want to comment on any other other question?
I'll let you do the privacy first. I have a small thing, but
okay.
Yeah,
no, I think, this is a really important debate and certainly gained a lot of attention after the Court of Justice ruling on beneficial ownership transparency that Daniela mentioned in her intervention. And what we have been saying at TI is that you always need to try to balance what is the public interest, right? And for some of these data sets we have been discussing, we believe there is a public interest in knowing who is behind the company for sure, what properties a company might own, and then I think the distinction there can be quite important as well when you're talking about public access. So if you decided that you want to own a property through a legal entity, then I think it's fair that there could be more disclosure rules than for those who decided to own a property on their own names. So I think you always try to find a balance. And I think the other important thing is that it doesn't mean that all the information about an individual needs to be made publicly available. Another way of finding a good balance is by layering what is disclosed. So in the case of a company, we are not interested in the gender, we're not interested in the home address of a beneficial owner. We want to know what he has in relation to that company. And it's the same with a property owned by a company. So I think there are different ways of doing that. And then finally, I guess we should separate privacy and security concerns. I guess those should be dealt with differently. If there are security concerns, then you can put exceptions in place where people can apply for their names not being disclosed, as long as they can demonstrate why making that available would put them at risk. So I think that's how we have been approaching the issue. Over to you.
Yeah, the only thing I agree with everything she said. The only thing I would add is, as a social scientist, we have examples of data being out there, and UK and France are two of them, and society hasn't collapsed because information on individual beneficial owners of legal properties is available to the public. And I'm not aware of any evidence, and I'm not sure how you do this, that like people's concerns about privacy are being violated, that there's more kind of targeting of wealthy individuals, like the many reasons that are made, or many arguments that are made that this data should be kept private. We have two countries that have experimented with this openness, and we don't see the negative consequences. We don't see the evidence supporting the arguments for privacy yet. I think we should study it and analyze and keep aware of it, but when countries experiment, we learn from it, and I think the experiments so far have been moderately successful and back up the case that Myra made, that there should be exceptions and that kind of thing, but it's not going to like tear us under by requiring corporate transparency.
No, and it's very interesting because you probably all saw after the Court of Justice ruling, there was an investigation published on the individual who triggered the whole thing. So it was a businessman from Luxembourg who initially actually went to court in Luxembourg challenging the fact that he had asked for an exception that he didn't get. And the Luxembourg court referred that case to the Court of Justice of the European Union. But then what journalists found, because of course, once this happened, everyone wanted to know who is this person. And journalists found while he cared a lot about his privacy and security and so on, his social media accounts were public. And he was posting all his trips and private jets here and fancy restaurant there and watches and this and that. So it was not really that he cared about his privacy, right? And what probably he cared about was that journalists also found he had a lot of connections with Russians officials and have been involved in several of the companies as director. So yeah, one needs also to look at the motives behind the very blank statements of, oh, I will be at risk, and so on and so forth.
Yeah, so a perfect example of the sloppy, silly ones that expose themselves to us gratefully. But, you know, one thing we haven't talked about is the use of trusts, which I can't say statistically if it's growing. Maybe David has a better handle on that. But one thing that we see is that there seem to be more trusts that we know about in the United States now, in states where, I mean, they weren't known to be the most hospitable to shell corporations. So this is troubling, and trying to get into who are the beneficiaries of the trusts or the creators of the trusts is a challenge for us. And something that we're obviously looking at. I guess that goes to your trend question, sorry. Yeah. But David, maybe you know something about...
I think we've seen some small increases that correlate with what you're talking about. I really think the CTA is going to move people into trusts, right? Like, I think we're going to start to see some things on the horizon, and trusts are a problem in every country, and I think it's a burgeoning industry, and I'm very concerned. But it's hard because we don't have access to U.S. data. It's decentralized. It's $100,000. Like, doing data work on the U.S. is very resource intensive.
Well, one thing that we do have, though, and maybe we get a sort of a wedge, is we have a lot of trusts that own property through corporations. Mm-hmm. And so if they're stuck having to disclose the corporate part, then maybe that's a wedge into the trust. Maybe that means they'll stop using corporations and just go to the individuals. I don't know. It seems unlikely, but...
I guess the main challenge with trust in most countries is that there is no obligation to register it anywhere, right? So the hand is going to come there, because what you have is a lawyer signing a contract between the parties, and that's it. How do you find this contract, where this contract is located, and what are the provisions?
But you know, this is where the civil confiscation tool is so important, because if we can find the property and we can link the property to an offense, everyone is welcome to come in and try to claim the property, but then, and a trust might be able to show that they have an ownership interest, but then they're going to have to answer the discovery of requirements of the litigation. How did you obtain the property? What is the source of your money? Who actually has any interest in the property? And that's when trusts won't want to participate. We didn't get any of the trust owned many properties in our 1MDB case. The trust didn't file one claim, even though they were the owner of properties. And we think, on the one hand, they didn't want to be involved in the litigation. On the other, and they had the discretion not to. And on the other hand, they didn't want to highlight their role to us so that they might become the focus. But we think also use of trust might be a good tool for us, because suppose the trust owns property in a jurisdiction that doesn't enforce our confiscation restraining orders or forfeiture orders. And there are several examples of this. If the property is there, but there's a U.S. financial transaction, maybe we can basically force the trustee to have to deal with us, because we can still complain against that property. And we can serve the trustee, the owners, everybody we know, we can advertise. And then they can't do anything with regard to that property that could violate the U.S. restraining order. Because either that could be an offense, or it could be a money laundering transaction, depending on the circumstances. So we can apply pressure to the trustee, maybe, to help us get the liquidated value of the property out of the jurisdiction that won't cooperate with us. So we are thinking about every lawful way to try to get around these structures and also to deal with our foreign counterparts who don't respect the treaty obligations or the convention obligations to provide mutual legal assistance in asset recovery.
Great, thanks.
Yeah,
do you want to comment?
Yeah, no, just one thing on something that you mentioned on the discussion about security, on privacy and revealing beneficial ownership information. We did an investigation as part of the Open Looks project, in which we found that one of the exceptions to reveal the name of the person who was behind a company was if you were a minor. So we found a lot of names of kids and babies who were then registered as the owners of these companies that own properties using this exception. So I think it's a really long discussion, and who and how you why you would say that your name can appear on a beneficial ownership registry. So yeah, just wanted to mention that.
Great. Do you want to weigh in as well on the question on the cooperation between journalists and law enforcement?
So we don't share information with law enforcement. I think it's fine that law enforcement uses the investigations that we publish to open investigations, criminal investigations, or civil cases. But yeah, I think the relationship is more like sources, and yeah.
Yeah, but yeah, maybe I can just add that in relation to that, because I think many journalists have this policy. Let's say, no, I feel uncomfortable about sharing information. And what we have is a partnership actually with OCCRP, the Organized Crime and Corruption Reporting Project, with TI, where we do exactly this. So we take the investigations that journalists are working on, and we try to collect more evidence and make sure that we have everything that is necessary, and we pass over to law enforcement. So that's one of the things we have been doing in cooperation. Any more questions? Oh, yeah, there is a hand there in the back, and then a hand here in the front, and another one there in that corner.
Hi, thank you. I used to work in Mexico in an NGO, and we looked at corruption in the health sector, how shell companies were being used. And I definitely think that transparency is one step to actually do something with this information, but I think the second step is what happens, like the impunity that goes. So I just wanted to ask you, what would be your good recommendations, because I think we have to now look at transnational cooperation, because most of the money that it's being laundered from Mexico, I'm being sure that it's being laundered in real estate in the United States, in many of your countries. So how we can actually start doing these cooperations where maybe, yes, we have high levels of impunity in Mexico, not rule of law, but then activate this mechanism so it actually gets something done and getting back that money to the countries where it's been stolen from.
Great, thanks. I think there is a hand here in front. Thank you.
Hello, I'm Kelly from OCCRP, covering South Caucasus. So my question is for Mrs. Mary, because it would be very interesting to hear your perspective on this. As a journalist, we stay away the law enforcement. We don't want to talk to them. We don't want to share our findings with them. As someone who covers Azerbaijan, we all the time find big properties of the state officials. Recently, we published a very big investigation about the chief security of the president owning over $130 million mansions, penthouses all over the United Kingdom. And when we look at his salary, it's like $20,000 annually. I mean, it's just impossible that he could afford the properties. But in Azerbaijan, the information is limited. We cannot find their holdings. We cannot find the money that can explain the source of $130 million. So for us, that becomes unexplained wealth with all the public information that we collected. But we cannot find the crime that has been committed. And in another case, when the National Crime Agency was trying to confiscate one of the properties and the money of one of the Azerbaijani MP, I was going through the court documents, and it just NCA kept saying that Azerbaijani side did not cooperate, like prosecutor office did not cooperate. They didn't say. So how you basically handle the cases of unexplained wealth when you have a country that refuses to cooperate because they are not going to sell their own basically official, especially if we are talking about someone who is close to the ruling family. And that's it.
Thank you. There was a hand there in the other corner in the back.
Yeah, thanks for a really great panel. Actually, my name is Václav Prusha. I work as an independent consultant, but I spent many years in Africa and Asia as an anti-corruption advisor. My question is actually a bit similar to the previous speaker. In my context, there have been two fundamental problems. The first one, absolute lack of cooperation from certain jurisdictions. And the second, a lack of operational independence. And that's, I think, two huge challenges that I have not heard from this panel. So perhaps a bit naive question, what can we do in this context? Because this is quite, I think, different situation to what we have in US, UK, France. Thanks.
Maybe I'll collect one more question if there is. Yeah, there.
Hello, thank you. I have two short ones. One is, how reliable do you think are like central beneficial ownership registers where companies self-comply or like declare their information? Mary, you were saying like you need more investigators and more resources in order to confirm and verify that the information is correct. So how reliable do you think those are? Or whereas it's more about leaks and investigations to follow what's hidden in those declarations. And the second one is how useful or how important is well-structured, interoperable information to combine with other sets of information where beneficial owner is just one piece of the puzzle. I mean, how important between other sources of information you think it is?
Great. Thanks for the questions. Who would like to start? Mary?
I don't want to take up all the air in the room, but since you are all my future partners here, let me try to give you something satisfying to think about. One thing I would say, if I understand the question by the woman who works in Mexico, if what you're saying is that you have some information that you think could be exploited by law enforcement to lead to prosecutions or asset recovery, there are so many good ways to provide those leads. The FBI has legal attachés in almost every country of the world, and if they're not in country, they're responsible for a region, and so they come periodically. So the FBI legal attaché structure is a good way. There's also a number of what we call transnational anti-corruption advisors, TAP advisors, and there's one here at this conference, Steve Young, FBI agent who is assigned to a region to try to even be more available to receive information that might be linked to corruption or other complex crimes. And I understand there will soon be someone in Mexico in that position. Also, if you have trusted, you could always go to the U.S. Embassy. You could go also to, in some countries, to the FIU, which in some countries is more trusted than law enforcement, but you'd be in the best position to evaluate when that's likely. But just some ideas about how to get the word across. You can also contact me. I'll give you my email, but also we have an email address, kleptocracy@usdoj.gov. Is another way to provide information to see if there's something we can do. There's also a network of anti-corruption asset recovery practitioners around the world. Again, you would be probably in the best position to know if that representative in Mexico is someone who you have confidence and trust in. It's usually a prosecutor representative and a law enforcement investigative agency representative. We get a lot of information through what we call the Karen network, which is this network of asset recovery practitioners. But again, you have to evaluate whether that's a channel in that country you have confidence in. So just to give some ideas about how to get information that's not being published. On the question of what to do with this problem of unexplained wealth, where the country, where the official is, doesn't seem to prioritize investigating that or prosecuting that. This is a huge problem. We don't have an unexplained wealth statute crime in our country, so we would have to try to figure out what crime may have been committed. Now, this is again where this civil non-conviction-based confiscation comes in, because the proof burden in criminal cases is beyond a reasonable doubt, the highest burden in our law. But in civil confiscation, it's preponderance of the evidence. So if we, for example, saw huge unexplained wealth, we would dig as hard as we could, looking at open sources, talking to whoever we could, to try to see if there's a particular transaction that this money might have resulted from, and try to push that through our investigation as much as possible. And then we might actually, even though we can at best show by a preponderance that the money comes from some illegal source, taking into account how low the person's official salary is. So I know I sound like a promoter for this non-conviction-based confiscation, but I really do believe this is the way to clean up corruption in terms of taking the assets away. People don't go to jail through this confiscation process, but we take away the profits, and we return them. So I think this is a powerful tool. And again, the FATF is now trying to make this a recommendation that countries will be evaluated on. The EU is moving forward to try to expand the use. We appreciate the arguments that you have to have well-respected due process in your country to have a system like this. We understand that. But where there is reasonable confidence in the due process of your justice system, your legal system, this is, I think, a really powerful tool. One other point, and then I will pass this off. One of the questions was, again, how do we handle, maybe it's the same question, how do we handle situations where the country doesn't cooperate? I think there's, in the US and around the world, more and more interest in developing whistleblower programs where there's not only financial compensation, but the possibility for relocation. And my hope is that if we could ever do that in a meaningful way in the United States for corruption information, a lot of people would come forward. Maybe they're the jet pilots who know that they flew pallets of cash around. Maybe they are the jeweler who sold a $30 million pink diamond to somebody, which we know happened. Maybe we can induce more cooperation because people could take the risk because they can relocate and they would have money to never have to work again. But just ideas. Maybe, David, you have...
Great, thanks. Maybe we need to start wrapping up, but maybe David and Daniela, you want to comment on the reliability of data and the importance of interoperability?
24 seconds on the clock. I don't trust a lot of this essential beneficial ownership data set. It's really hard for us to validate. I think it's incumbent on the law enforcement authorities to collect actual identification information, pictures, passports, that kind of thing. What I do suggest is that you do need to combine data sets creatively. So income and asset disclosures of politicians, two countries where they mirror each other. There's a lot of different ways to validate if you can create an ecosystem of data and do some creative things to find out where the weaknesses are. That's most of what we do, is that kind of like validation or benchmarking exercise.
Great.
Yeah. No, I don't know if the lady there, did you say that you're a reporter? Are you a journalist? Or are you a journalist? What? Oh. Okay, no, because I was going to say that, like for journalists who are working on countries where you don't have like access to information, but you have leads, I mentioned a couple of cases from Venezuelan reporters who have done a great job. And when you don't have information in one country, find it in other countries where you have like open access to information. That's how reporters in Venezuela have been able to do these great investigations, by looking for this information in other places. So.
Great, thanks. So our time is unfortunately up. I think we talked a lot about challenge, but that's the sign we have to go. Loud enough to continue. Is the battery finished? Thank you. Thank you so much. Yeah, so I think we talked a lot about challenge, but I guess we can also live with a little bit of optimism that there are developments, and that at least we here, we all continue pushing for better information to be available, for better laws, for more resources for authorities to pursue those cases. And I thanks a lot the panel for the participation. It was a very interesting discussion, and you all for very active participation. Thanks for the colleagues taking notes and the ones helping with the sound. And yeah, see you the rest of the conference. We have another interesting session tomorrow on enablers at 2:30, so join us there to continue some of this discussion. Thank you so much.